right, we'll now move on to the second case on the docket today, Arch Insurance Company versus Kubicki Draper. Just a second.
Good morning. May it please the court, Mr. Chief Justice. Edward Geddes on behalf of the petitioner, Arch Insurance Company. With me at counsel table are co-counsel Ben Byard and Brittany Bork. Under the tripartite relationship in Florida, an insurer's injury arising from the malpractice of retained counsel requires a remedy. Whether that remedy is through a direct action for malpractice based on privity, whether it's under subrogation, or whether it's under a non-client beneficiary theory, a remedy should exist. The insurer should have the same access to the courts to remedy its injury as any other client. What I propose to do this morning, with the court's permission, is to address the issue of privity first, then subrogation, and then, time permitting, the non-client beneficiary theory.
Can I ask you, I'm sorry to interrupt you, can I ask you a question?
Certainly.
Has there been, I'm wondering if there's been an evolution a bit of your position in this litigation. It seems like, and I'm wondering if this explains kind of the cursory analysis that the fourth TCA did on this question. Did you initially begin arguing that there was kind of an inherent attorney-client relationship based on between the insurer and the counsel, based on this tripartite relationship and the unique situation, et cetera, versus treating it more as just a basic kind of factual question as to whether in this particular case, based on the way this law firm and this insurer handled this case and the interactions they had, that there was an actual attorney-client relationship formed? I'm wondering, because the record is strange, that the litigation guidelines aren't there, the contract between your client and the lawyer isn't in there. So I'm wondering, so is your argument, it seems like I'm seeing now in your briefs that you are making an argument that in this particular case there was an attorney-client relationship. But have you always consistently made that argument, or did it initially start out as more saying that there's kind of always an implied or inherent attorney-client relationship there?
Well, I think our argument has always been tied to the existence of the tripartite relationship. And I certainly would be reticent to ask this court to make a decision broader than it needs to resolve this particular case. I'm not quite sure why the fourth chose not to delve into the issues the way I thought they would. But in a great many situations, given your typical duty to defend policy that exists in the market, the tripartite relationship will give rise to this idea of dual clients, of co-clients. The tripartite relationship arises, as Your Honor knows, the moment that the insurer retains counsel to represent the interests of an insured in a particular claim. And counsel in that scenario treats the insurer, as happened in this case, as a co-client. Not as a sole client, but as a co-client with the insured. And when we think about what traditionally creates an attorney-client relationship...
You're saying that in all cases?
No, I can imagine scenarios, certain types of policies, maybe a non-duty to defend policy, where the selection of counsel and the payment of litigation expenses initially is done by the insured. The insured doesn't control the litigation. That's controlled by the insured. So there are scenarios where there's a tripartite relationship because there's an insurance company involved that might be paying a claim, but it doesn't give rise to the co-client relationship with respect to the retained firm. So, and certainly in this case, we contend it is. But it doesn't, depending upon the nature of the policy and the duties that were created thereunder, it may not.
So when there is when there are duties running both to the insured and to the insurance company, as an attorney-client relationship, shouldn't the insured know that? Don't the rules require that there's notice given so that the insured knows that?
The rule requires that the retained lawyer specify that, yes. It does not require the insurer to do that. It requires the retained lawyer to notify both the insurer and the insured what the scope of the relationship is and where any loyalties lie. And in fact...
Right, so in this case, the record seems absent of that. And it seems like I could see why the trial court and the appellate court ruled that the record doesn't support some type of separate attorney-client duty running from the lawyer hired to represent the insured, then also representing the insurance company in this case.
Well, I respectfully, Justice Polson, I think that places the burden where it doesn't belong. In other words, in this scenario, Arch retains the law firm to represent its insured, Spear Safer. The retained counsel informs the insured that Arch has retained it and says nothing more other than attach the statement of insured client's rights, which describes at length all the ways the insurance company is going to control this litigation. There is no clarification, as required expressly by the rule that says from the retained law firm to the insurer and to the insured, by the way, our duties are solely to you, the insured. There's nothing there. And I think it places the burden where it doesn't belong to say that it's somehow incumbent upon the insurer to do that. The insurer has this existing relationship with the law firm. They're panel counsel.
Well, they're paying the defense counsel, but I don't see where there's, what in the record shows that there is an attorney-client responsibility from the lawyer to the insurance company? What document?
There are numerous documents here that reflect how the retained firm interacted with the insurer.
Well, there's reporting requirements, and that's true in every kind of transaction involving an insurance policy where there's hired counsel.
It's more than that, Your Honor, respectfully. There are multiple instances in this record of retained counsel providing advice only to the insurer, and leaving the insured out of the equation. And I can cite the record citations.
Yeah, go ahead and do that, please.
Yes, it's record 1246 to 52, 1252 to 58, 1262, 1263 to 72, 1275 to 89, 1290 to 91, and 1295 to 96.
And what advice in those record sites is the lawyer giving to the insurance company?
The advice that the lawyer is giving in those instances are about how should we should handle the case in the following manner for the best possible outcome. In one of them specifically, and this is directly at record 1278, which is part of one of those citations, the retained lawyer, the retained counsel, advises Arch on Arch's exposure to a potential bad faith claim. And the insured's not copied on that correspondence, on that analysis. What we have here at every instance, at every indication in the interaction of these parties, is that everyone understood that retained counsel was representing the interests of both entities. In fact, when you look at, for one example on the record, it was necessary to retain an expert in this case. The expert understood and believed that Arch was the client. Not not Spear Safer. The retention letter required Arch, as the client, to sign off on the retention of the expert.
But
Let me go ahead. So in a duty to defend with a duty to defend policy, the insurance company is always going to be paying the fees of the lawyer, correct?
Yes.
And the insurance company is always going to be paying for the loss. And the insurance company is going to be the one that suffers damage if there's malpractice, correct?
Correct.
And that would be true whether or not there's a attorney-client relationship between the insurance company and the law firm, correct?
Correct.
Given those facts, I mean, just in terms of what the right answer is, why would the absence of an attorney-client relationship really have any impact on what the right answer is? I mean, it just seems like from a public policy perspective, which is really what we're talking about, that the party that pays for the lawyer and suffers the loss and suffers the damage if there's a malpractice ought to be able to recover when there's no conflict of interest
Correct.
involved.
And that's critical, Your Honor,
Yeah.
because
So, I mean,
clearly when a conflict of interest arises, a different scenario presents itself, and those are not the facts in this case. But I think Your Honor is correct, and I think what some of your sister courts in the country have dealt with as they've reached the same decision and come to the conclusion that there should be some remedy, they've turned to subrogation.
Well, but he's actually, it seems like his question's going to the restatement view.
Sure,
And
which
so
is
I'm
the non-client
Right.
beneficiary
And so
idea.
what's the precedent if it would be an innovation in it seems like we have a baseline in Florida that you owe duties to your clients. And so if this case gets resolved on that basis, there's no new ground broken. There may be a factual question as to whether there was an attorney-client relationship here. If you go the restatement route, what's the precedent in Florida for how this court decides whether to essentially adopt a new rule of law that imposes duties where they haven't previously been recognized by our state's law? I understand that the restatement says what it says, and there's other state Supreme Courts that have gone down that path, but when this court is deciding whether to create a new duty or to recognize a duty that's been out there, if you're discovering, the common law, I mean, how do we analyze that?
Well, I think, I'm not sure that this requires, under the non-client beneficiary theory, the announcement of a new rule.
Well, there's no Florida precedent that says that outside of the will context or the private placement or whatever,
Memorandum
the
in Cowan.
investment, that lawyers owe duties to non-clients. And those cases are based on the intent of the client being to help these third parties. And I don't think it's plausible to argue here that the insured has an intent in their lawyer-client relationship with the lawyer to benefit the insurance company.
Well, I think there certainly could be. I mean, for example, one of the reasons that allowing the claim of the insurer against retained counsel in a situation where there's an allegation of malpractice, that recovery inures to the benefit of the insured as well, because the insured's policy limits, should Arch succeed and recover, are replenished. So there is even still a mutuality of interest there. I think...
No, but the services, though, the services that are being provided in the will context and in the private placement context, what the lawyer's work on behalf of the client is really for the benefit of someone else.
There's slightly,
in terms of the intent of the client.
Your Honor is correct, but I think if one delves a little deeper into Cowan-Leibowitz, what Justice Quintero wrote in the opinion on behalf of the court was focused on the idea that when the relationship was created, there was an expectation on the part of the lawyer in that case that was preparing the private placement memorandum that its representations in that memorandum would be relied upon by third parties.
Well,
Right?
could you address, though, how do we decide when let's assume for the sake of argument that this would be announcing a duty that we haven't recognized before in Florida. How does our court decide whether to do that? Is it just a pure sort of policy cost-benefit analysis, or what should be guiding us? I mean, people's sense of kind of what's fair, what's the right answer, should the insurer really be left holding the bag? I mean, how, to the extent possible, what's the most objective way for us to analyze whether there should be let's, again, for the sake of argument, this new duty recognized as a matter of Florida law?
Well, I think traditional tort traditional tort principles guide this analysis. In other words, we allocate, historically, under tort law, we allocate risk and we allocate liability, and we place the burdens where they belong. And in this instance, one thing that has remained unanswered throughout all these proceedings is, well, if it is proven at trial that retained counsel was in fact negligent, committed malpractice, how are they held accountable? This is a basic tort principle. We allocate the risk, we allocate liability based upon where society deems that risk should be borne. And in this instance, it's traditional malpractice law. All we're doing is substituting the insurer into the shoes of the insured.
That's what subrogation does, right?
Exactly, Your Honor. And that's why some of your sister courts have chosen down that path, because the subrogation path avoids maybe some of the hairier issues of attorney-client relationship and conflict, because the insurer steps into the shoes of the insured. But
is there any practical difference going forward, in this case or any other future case that you can imagine, between the subrogation approach and adoption of the restatement? I mean, would it play out differently in different cases? Have you thought about that?
My crystal ball does not function that efficiently, Your Honor. I wish it did. But in reviewing all of the available case law, it strikes me that at the core, what all the other courts that have looked at this, whether they get to the end point of allowing a malpractice claim, whether they do it through subrogation or whether they do it through the non-client concept, it's still the same claim that there was a duty of competence owed to a party. And I don't see how that should change depending upon the case, whether it's subrogation or non-client or a direct privity scenario.
I mean, at least on its face, though, you're alleging it's different between saying you owed a duty to me and you breached that duty by doing X, Y, and Z, versus in the subrogation context, you're not saying that the duty to the insurer isn't part of the equation. The only duties and the only acts that can be relevant are ones vis-a-vis the insured. I guess the question, I mean, if the interests were aligned in the first place,
Sure.
which is kind of a predicate for whether there would be a duty in the first place or subrogation, then does it end up being the same exact conduct that's at issue? I mean,
I believe so, Your Honor. I think that's how it ends up playing out, especially, and certainly in this case, because the interests were exactly aligned. I see that I'm well into my rebuttal.
You are.
So
You're observant.
I would like to reserve it and have an opportunity to come back up. Thank you.
Good morning. May it please the court, my name is Chris Carlisle. I'm here on behalf of Kubicki Draper. With me at council table is Stephen Hunter, and representing Kubicki are Brad McCormick and Karen Bellis. Your Honors, I think one of the starting points in this entire question needs to be what exactly are they asking for, and what can this court do about it? The nature of the tripartite relationship in and of itself does not rise to the level of creating a duty or an obligation between the insured and the law firm. That's clear. But what's clear or not clear is in the first page of their initial brief, they seem to suggest that under the tripartite relationship, both the law firm and the insured were in fact clients, and the attorney-client relationship was present. We've heard a recession from that today. And indeed, in their reply brief, they receded from that and said, no. There are situations that could conceivably exist where a sole representation of the insured does occur, and therefore there wouldn't be this obligation or there wouldn't be this right to sue in malpractice. You heard that today. You see it in their reply brief. That then takes us to the 4th District certified question. And one of the points that we made in the brief throughout this was, how broadly are we going to attach to this, or how broadly is the question going to attach to these facts in a separate matter? What is the certified question?
Well, let me give you a hypothetical. Let's say that an assigned lawyer representing an insured absolutely malpractice, totally misses a statute of limitations, no question about it. And so there's a total loss,
Right.
$5 million. Policy limits are $3 million. So the insured's on the hook for $2 million. The insurance company tenders the $3 million. What then is the responsibility of the law firm, malpracticing law firm, and who do they have to pay? Does the client get $2 million?
Your Honor, that's an interesting hypothetical question, but it doesn't...
I think so, too.
I think so also. But as far as the duties that are owed here, I'm trying to follow your scenario in terms of what we're talking about.
Okay, so...
And in terms of the facts of this case, obviously it was within policy limits, which wasn't really addressed during the first presentation.
So in my hypo, the policy limits aren't sufficient to satisfy the total loss.
So there's an excess judgment.
Right? So what happens in that situation? Does the client get $2 million? And the insurance company get $3 million?
I think the client has the ability to sue under that situation for the legal malpractice because, again, it's in excess of the policy.
He's asking how
limits.
much.
Yes,
Yeah, I think it is. The question is how much, and I asked a clarifying question here. Are you assuming that there is no attorney-client relationship with the insurer?
Yes.
Okay. I mean,
Right.
I thought
If
that
there's-
was
right,
implicit.
that's- again,
Because we know if it's clearly established that there's an attorney-client relationship with the insurer can sue, right?
And so the question then becomes our case, and these are factually based considerations in virtually every case, which this court has recognized through the years. And the subrogation issue comes into play, but potentially, again, the point being...
So your answer then
Yes, Your Honor.
is that the client gets $2 million and the insurance through subrogation gets $3 million. Is that your answer?
I'm just, based on your hypothetical, I'm speculating as to how that would play out, but I think the subrogation rights would then...
Well, it's operational law. It's very pertinent.
Yes.
And it's pertinent to how the subrogation works. And why should it work differently in that scenario than where you settle from within policy limits but still have harm caused by the malpracticing lawyer?
Because the biggest answer to that question is that the harm that is suffered by the client when it settles within policy limits is that they were not damaged financially. And so we go back to paradigm
But why
case,
should
which
the
that's
insurance company still not step into the shoes and be entitled to sue through the subrogation claim for the amount paid?
For several reasons.
So let's assume there's policy limits.
Right.
Instead of 5, it's 10.
Within policy limits. The
And
reason that shouldn't be
within
allowed to
policy
step in-
limits, you still got 5.
Yes.
Right? So the client doesn't have to, the insurance company pays the whole 5, right?
Right.
Why shouldn't then the insurance company, through subrogation, be entitled to recover the whole 5 instead of the malpracticing lawyer entirely walking away from this?
Again, for various reasons. Number one, Florida law on the point dealing with subrogation and/or assignments says that in this context, that is not allowed. So if this court wishes to change the nature of the law that's existed in this state and parties have relied on for many years, obviously it can. But secondly, in the context of a settlement within policy limits, what harm, and the harm to the client, to the insured, what harm am I subrogating? How is that harm being transferred to the insurance company when the client itself, who paid premiums, who received the benefit of its bargain, who had a claim settled within policy limits, what harm is it suffered that could then be assigned and or subrogated to the insured?
That's true. That argument would be true in any circumstances by which an insured has bought insurance.
Which, again, is also what the restatement that we talked about contemplates, saying that in those type of circumstances. So again, the one-size-fits-all question.
There is a subrogation clause in the policy.
Correct.
Right?
And again, it could, the impact or the effect of that clause would have obviously depend on the individual circumstances of the given case, which goes back to the underlying premise of the whole reason that we're here today. This court long ago adopted rules talking about how the parties themselves get to define the nature of the relationship here, based on the contracts, based on the understanding of the parties, etc. This court rejected the contention that has been accepted by many other courts throughout the United States that a dual client relationship always exists. I cited to you the Commission 2 back in 2002, adopted by this court in 2003, where that was plainly acknowledged. So what do we have here?
Well, what's wrong? We have our rules.
Yes.
That put a duty on the lawyer to let both the insurer and the insured know whether the lawyer's representing them. I don't see any compliance with that in this case. There's nothing in the record that suggests that the law firm did that, is there?
No, Your Honor.
Okay. What's wrong with the default rule that says if the lawyer doesn't do it,
What's
we're going
wrong
to
with that
presume that
is
he's got, that there will be a presumption that he's representing both, and he's going to be on the hook for representing both.
Well, again,
If the lawyer fails to do what our rules require the lawyer to do.
Well, again, essentially what you'd be doing then is saying that despite all the evidence in this case, despite all the conversations, all the relationship, all the correspondence, despite the documents themselves, we're going to punish you for screwing up and not fulfilling this duty that we have specified.
This whole thing is about being punished for screwing up. I mean,
well,
that's,
it's about the right to do so and how you protect that right, which is something we haven't touched on yet. And going back, so in answer to your question on that point, Your Honor, again, the question becomes at that point, you know, what is the nature of the relationship? And it always goes back to that in this case, and what are the rights that are applicable there? If we're talking about the situation where the insurance company clearly has the right to control this, and again, one of the things this court needs to think about is all the things that were mentioned here as establishing this relationship seem remarkably thin. And the insurance company, I think we would all agree, under the law and under the rules, has the ability to control the nature of that relationship. If the insurance company, through a letter of understanding, through the guidelines, which again don't seem to be in the record, if these things were done, we might have a different case. If we had a clearly established situation where privity was there, what's the need for this court to resolve this question?
All those arguments make sense to me, and I tend to agree with you, but I'm concerned about all those record sites your opposing counsel just threw out there, including, he said, was advice given to the insurance company on a bad faith claim.
Well, Your Honor, again,
what is that about?
I'm not familiar. I need to review that particular one. It wasn't pointed out or emphasized in their brief besides the string site, which I reviewed, but I don't recall it being quite that explicit. But even if it was just one site or one letter where that was mentioned in the context of years of this control the issue, this is a factual issue. We have, again, their initial record at Supplemental Record 2101 is the initial report to them from Kubicki saying, our client, the accounting firm, from day one. So the point being, do the parties in any situation like this have the ability to clarify and specifically set forth the nature of the relationship? Of course they do. When they don't do that, like happened in this case, should they come to this court and say, we had the right to do it, we had the ability over these years to specify clearly what our rights were, whether we could sue for malpractice, what the nature of our relationship was. We didn't do that, but because they failed in their duty to inform us at the beginning or clarify this, we're asking you to bail us out.
Well, I do think
that I do, a remedy here.
But I think if you're each kind of arguing, I mean, you're arguing for one presumption, the amicus argues for this different presumption. It seems like the side that can point to a specific rule that places a duty on, in this case, the law firm to clarify. I mean, it seems like they're better off. But let me ask you, I mean, it seems like there were some questions before about the restatement view. Obviously, the certified question is written in a way that if the court decided that we were going to adopt that view and say that there's a duty to a non-client in this context, I think it would be a good use of your time to explain, you know, why applying the normal criteria that a court would apply in deciding whether to recognize a duty like that, why we shouldn't do it.
Number one, because this court has put forth the rules and made it clear that, again, you can obviously do whatever this court wishes to do, but you'd be dramatically changing the law that's existed in the state of Florida for many years, as recognized 20 years ago by this court. You'd be taking, again, a situation where you're saying, parties, we don't trust you to define these things. Number three, you're doing exactly what I mentioned before by saying about where the fault lies if this was not complied with. The point being that
but
the
again,
nature
it hasn't. But remember, with the restatement, the attorney-client thing goes out the window.
Well, okay, but
and
so you're saying
that's the whole. That's the
right,
point.
Do you wish to create an entirely new cause of action that has never existed in Florida before, based on the restatement? Can you do that? Of course you can. But subsection G that we're talking about applies to this particular circumstance and suggests that you shouldn't. Which again,
no. What do you mean? The restatement.
Yes.
Whatever the merits of the restatement position might be, The only qualifier on the restatement is that where the interests are aligned. If they're not aligned, they would say there's no duty. But I mean, the restatement seems to very clearly contemplate that in the absence of a conflict, there will be a non-client beneficiary duty recognized.
It contemplates that at one portion of the rule, but if I may, from section G in 51 that you're referring to. For example, if the lawyer recommends acceptance of a settlement offer just below the policy limits and the insurer accepts the offer, the insurer may not later seek to recover from the lawyer on a claim that a competent lawyer in the circumstances would have advised that the offer be rejected. Allowing recovery in such circumstances would give the lawyer an interest in recommending rejection of a settlement offer beneficial to the insured in order to escape possible liability to the insurer. So again—
Does that say, though, that the only reason why you had to offer that in the first place was because of malpractice that preceded it? I mean, that seems like that's more of a whether there was a breach of a duty question as opposed to a standing question, which is what we're looking at here.
One of the problems, again, Your Honor, as I've suggested throughout this, is that the nature of the tripartite relationship can be many varied and take on many forms. The individual circumstances in a given case can be many varied based on whether it's settled within policy limits, whether it's not, whether there was a clear finding of malpractice, which wasn't the case in this case, or not. There are a lot of things that can occur. And so to suggest that again, one size fits all, to answer this question, the one before you in the affirmative is to ignore all the nuances, to ignore the fact that the parties can control their relationship and allow a malpractice suit without any distinctions, despite the fact they've made some distinctions today. Based on the concessions today, you need to change the
Could I ask
question.
you this? Do you
Yes, Your Honor.
concede that there is privity of contract between the law firm and the insurer?
No.
No privity of contract.
The trial
I'm
court—
not talking about a lawyer-client relationship. I'm talking about privity
Are
of
you
contract.
talking about in this particular
Yes.
circumstance, when the trial judge
They didn't-
and
they
the
didn't
three
con-
DCA judges said there wasn't? That's the brew.
I'm-
I agree with that.
Are you saying the
Yes.
insurer did not contract with the law firm?
I'm saying that there was no privity of a
Are you
contract
saying,
sufficient to
let me
create—
restate my
Yes.
question. Are you saying that the insurer did not contract with the law firm?
I'm saying there was no contractual relationship with the law firm sufficient to create an opportunity to sue for legal
So
malpractice.
would you concede that the insurer did contract with the law
The
firm?
insurer agreed to pay the fees to the law firm and to—
that a contract?
and to request—
That would be a contract, wouldn't it?
The nature of the contract, again, with the tripartite relationship, we're dealing
So
with
if the
complex issues that
Well,
go beyond that.
Well, but
Privity
I understand
didn't
that. I understand
exist.
that's your position.
There was a
But the
relationship
reality
to pay
here
the
is
fees.
that
Yes.
if the insurer had stiffed the law firm on the fees, there would have been a suit based on a contractual relationship with the insurer. Isn't that correct?
I would believe that they would sue for those fees, yes. The question in this case becomes whether or not that relationship, whatever it is, whether they have to comply with guidelines, advise the insurer, do certain things, is sufficient to create a dual client relationship, which it's not, and whether or not the privity of contract concept exists is sufficient to allow that relation to exist, which the Fourth DCA and the trial court found no. And again, looking at the case that is actually before us, what are we left from their side to suggest this relationship existed? A letter from an expert that was not a party to the suit, a couple of sort of in no way clarifying comments during a deposition over the course of many years of litigation that there were certain responsibilities owed to the insurer.
But counsel,
It's
what's
as thin as it can be.
I'm sorry to interrupt you. What's the baseline test legally for whether there's an attorney-client relationship?
I think, again—
Just the black letter test.
Again, I don't know if there is a black letter test, and that's why, again,
No, I think there's two.
think—
I think I've seen two.
Okay.
One is the subjective intent of the would-be client, and the other is objectively looking at the behavior of the client and the lawyer. What did they think?
Correct.
Right. And
I
it
would-
seems.
I
And
would
so,
agree.
why isn't there at a minimum a factual dispute on this record, as clearly as to the subjective intent of the client? But even if you think that the right thing to be looking at is the objective behavior of the parties, I mean, why isn't there at a minimum a factual dispute as to that?
Again, Your Honor, the question becomes, was the record, and they suggest in footnotes that maybe there are factual disputes, and whether or not the nature of the relationship was as clearly defined as it should have been. We have the record that we had before. It was sufficient, given that at that point in the litigation, which had been going on for years, for the trial court to say, based on what has been developed so far in these facts, we find that the relationship is lacking. But again, going back to the report that this court approved, exactly what you're suggesting. The dual client relationship and whether or not it exists is a factual and legal question depending on the circumstances and understanding of the parties. That is the reality of it. And so how, when we have such a factually based consideration that goes into the determination of the tripartite relationship and what it means, can we agree to answer a certified question that is so broad and, again, takes none of this into consideration and establishes or creates the right to sue
Can I ask
under
you a
those
question,
circumstances? Yes,
please,
Your Honor.
Mr. Carlisle? So I'm interested in your assertion that we should not create a new duty for the law firm here. And I recognize that there are plenty of cases or instances in which this court has created new legal duties in order to support a new cause of action. The last one I remember is conspiracy to commit economic harm. And that's a pretty big leap when you impose on people that never had a duty before a new duty that can result in liability. Here, the duty that we're talking about is a duty to provide competent legal representation, which is a duty that this law firm has, correct?
They owe that to the client, yes.
They have this duty. So in that sense, we're not creating a new duty. The duty exists and exists in this case. Your position is that it's an unenforceable duty in an instance where the party that's harmed is not the client. And it seems to me that it's a very small leap to say that the duty ought to be owed to the party that paid for the services and the party that was harmed by the breach of duty. That just doesn't seem like it doesn't seem like the same thing as creating a new duty to create a cause of action.
I understand where you're going with that, and I understand the nature of trying to recognize the public policy behind if there is truly something that went wrong, there should be a remedy for it. Mm-hmm. But I think even your question goes to the complexity of creating what you're seeking to create, meaning under what circumstances does this arise? In every situation where the tripartite relationship exists, does that duty exist? I think I've heard from opposing counsel today and in the reply brief, no. So are you limiting the question and saying when it is absolutely clear that a relationship has been created, then they have the ability to do this? Are we suggesting it exists in all circumstances? Are we suggesting it exists in circumstances when the case is settled within policy limits? These are exactly the problems that I'm talking about, and this court needs to consider when it's going down this road and trying to say, we think we're trying to find an answer to this problem. I would suggest...
I'm sorry, counsel, isn't an answer to the question, though, that it's possible that it's clear that if the lawyer owes a duty to the insured, that it's possible that the insurer will become kind of an incidental beneficiary of everything that the lawyer does on behalf of the insured. But doesn't it in terms of whether, the significance of imposing a new duty, doesn't it fundamentally change potentially every decision in the case that the lawyer makes when they know that they have to be worrying about not just the interests of clearly the one client that they have, the insured, but also this entity that they now owe a legally recognized duty to, and essentially it adds to the equation of things that need to be thought about in terms of every decision.
I agree.
Obviously, most of the time,
yes,
there won't be a conflict and there's no issue and
right,
things work out. But, so there is something significant about saying that you owe a duty to the insurance company,
I agree
right?
with you, Your Honor. I think also, and I'm just about out of time, but if I can just answer your question. The other question that becomes, or the other policy that you're talking about, and what is on a lawyer's mind in these circumstances, was pointed out by the Fourth DCA, and it's been pointed out at other times. If you create this situation where they are adequately representing the needs or the rights of the insured, and this case settles within policy limits, what goes through the lawyer's mind during those negotiations during the course of that lawsuit? Knowing that perhaps I'll be second-guessed later on down the road by the insurance company if you create this ability to do so. And that is a significant factor that weighs into this. And the suggestion that public policy in this case impacts the decision, it impacts the insurance companies is what they're suggesting, but your scenario, or what I just brought forth, suggests that the public policy of the insured should be considered here, and when that is the case, Court should not go ahead and create this new duty, should rely on the ability of the parties themselves, as it has done throughout our history, to create this and not create another exception to the privity requirement.
I know that you're over
Yes,
your
Your
time, but doesn't the restatement deal with that dilemma by saying that there's only recovery or potential recovery if there's a breach of duty and there's no conflict of interest between the insurance company and the insured?
Your Honor, again, the individual conflict of interest, and there are cases that go back, and again, the nuances that
missing
can
a statute
exist,
of
the
limitations defense, I mean, that's the kind
The
of...
restatement, again, says what it says, but we also go back to the Paradigm case, which they've relied on, which says that in situations where everybody knows from the start that potentially the recovery is in excess of the policy limits, there's an inherent conflict there, we're not going to extend it. So again, multifaceted...
They adopted the restatement position.
I'm sorry?
But then they went ahead and adopted the restatement position.
Again, Your Honor, if you're being asked to adopt the restatement position, I would suggest that he shouldn't for the reasons I suggested, but also taking into account the nature of the individual relationships and the fact that this state has not said that the tripartite relationship automatically creates dual clients. Thank you very much.
Let me address in my remaining 2 minutes and 42 seconds the points. I'll start with Chief Justice Kennedy. Not only was there a contractual relationship between the insurer and counsel, they counterclaimed for fees. So there was clearly a relationship, and they have not disputed in any way, shape, or form that there was an existing relationship as panel counsel, that they were subject to the billing guidelines. There was a contractual relationship.
Do you dispute, though, that in this context, when the courts talk about whether there was privity, that they're baking into that the concept of an attorney-client relationship, that it isn't sufficient merely to say that there was a contract between the insurance company and the
I agree.
lawyer?
I think that baked into the notion that there is a contractual agreement, and I think in Espinoza, baked into that is this idea that there is some client-attorney relationship. There is some duty on the part of counsel to represent the interests of the person with whom they're in a contract. And I think that is definitely the case here, that they were representing the interests, and I think the record citations when reviewed will show that. My colleague here asked, well, what documents are in the record that show that somehow the retained counsel understood they were representing Arch? Their intake form is in the record, at record 2063. Their intake form for the firm shows the insured, Spear Safer, as the insured, and it shows Arch as the carrier client. They understood. Even on this limited record, they understood. I'll leave the court with one suggestion, and I thought there was an interesting analogy.
Wouldn't you agree that if you're basing your argument on the fact that there exists an attorney-client relationship between the insurance company and the law firm, that there are issues of material fact that summary judgment would not have been appropriate? I mean, you can point to some things in the record that go one way, but I mean, if that's...
And I think that's why we included in the footnote the possibility that the court may not feel fully comfortable on the limited record to conclusively say, in this case, yes, absolutely, there was privity with a client and attorney. So I understand that. I think that's less so the case with the other two theories, subrogation and non-client beneficiary.
Well, it wouldn't be the case at all with the other two theories, would it?
Right. I was trying to soft pedal the position a little bit, Your Honor.
Don't soft pedal it.
I'm out of time. I would suggest the court review the Hogrev decision from the 5th DCA of 2018. It presents an interesting, analogous, though not factually the same. We would ask that you reverse the 4th District's decision and remand. Thank you.
All right. We thank you both for your arguments today, and the court will now be in recess for about 10 minutes.
All right.